So what are we going to be discussing today? So we're going to be discussing, here we go, I need to get myself out of the way. We're going to be discussing what an easement is. We're going to talk about some historical context, mostly about easements, but really about real property law to help you guys have the context that you need to understand why we have this rule and why it's tested on the bar exam. As always, our lessons always offer vocabulary. So by vocabulary, we mean basically these very legal, technical terms that tend to bog down really most students, but certainly foreign trained lawyers, because they're very American in that sense, the legal jargon. And we define them. We put them in lay terms so that you know what it means, because a lot of times they are $10 words with 10-cent meanings. And so we go ahead and take the process of you having to research and figure out what it means and understand it out of it. We give you vocab lists so you can just know what the definition is and move on and get to the substantive part of understanding the rule. And today we're going to talk about how easements are created. And we're going to work through an easement flow chart that we've developed. We make this freely available to you all, so please circulate it, take it, make a better version of it, make it work for you. The flow chart that you're going to see today is an example of many flow charts that we do. And the reason why we use them, I'll get into in more detail later, but it's because the idea is that you will learn the rule, meaning the black letter law, and you will learn how the rule will be tested on the bar exam. Those are the two things that you need in order to get a passing score. And then we're going to take an MBE question together, a licensed MBE question, so that you all can see how the rule that we're teaching you applies to a real question that is tested on the bar exam, and how to use the study tool, the flow chart that we're giving you to get the right answer. So a little bit of historical context of American property law. So a lot of other countries have limitations on who can purchase property. Sometimes these limitations are based on if you're a citizen of the country, sometimes on your gender, if you're a man or woman, sometimes on your marital status, sometimes on your age. Even if the purchase of land is not itself limited based on those demographics, there is limitations in other countries on how property can be devised in a will, meaning who can you leave your real property to. So for example, a lot of civil law countries have legacy statutes, which means that you can only give a portion of your real property, your estate, to someone who is not your child, but not all of it. And all of these laws are based on the traditions and customs of each country, and they prioritize different objectives when it comes to who is going to own property and how and why. In the United States, it's almost the opposite. We want to limit the laws and the rules that tell you what you can do with your property. And this is mainly because the United States were originally the colonies that revolted from the king, that had a lot of absolute power on what people could do with their possessions, including their real property. And the founders of the country decided that they did not want that kind of legal structure within the United States. So really all the rules that you're going to see as far as real property are going to be there to limit government intervention, if you will. And more than anything, set out a list of guidelines for which property can be transferred, but there won't necessarily be substantive limitations on transfers of property. So as long as you own it, you can sell it. As long as you own it, you can devise it to someone in your will. You can also decide what level of property you're going to give them. Are you going to give it to them outright and let them do whatever they want? Which would be a fee simple absolute? Are you going to give them a life estate, which means they'll own the property the duration of someone's life? Could be their own, could be the person who gave it to them, could be a third person. Are you going to give them property that is going to last during as long as they don't do something, or as long as they do something, or until a condition occurs or does not occur? And this is all more covered in present estates. We do cover this in our lessons, but we won't be covering it here. We're just talking about easements today. But it's just to give you a general idea of how American property law works, right? It's really there to promote capitalism and land utility, right? The rules are there to make it easier to sell, will, take, and use land. And so keep that in the back of your mind as you're learning property laws for the bar exam, because it'll help you understand the context and the reason why these laws are so weird, especially to people coming from civil law countries where property law can be substantially different. So let's see, key terms, as I said, for the vocabulary. We always lay these out for you and we interpret them, if you will, into lay terms. So the first one is real property. Real property is immobile, tangible property that can be sold, rented, or devised in a will subject to the property interest limitations, meaning you can only give what you own, but you can do whatever you want with it, and within the confines of the law. And this real property is anything that is not movable. So houses, warehouses, buildings, trailers, to the extent that they're not easily movable on wheels, etc. Next is an easement, which is what we're going to be covering today. So it's a non-possessory interest. You're going to hear me go into that in the next slide. It's a property interest, which essentially gives you a legal right to use another person's land for a specific purpose, but it's limiting. It only lets you use another person's land, and we'll get into it into the next slide. A servient estate. What is a servient estate or a servient parcel? So it's the parcel of land, meaning the piece of land on which the land that is subject to the easement is, okay? So it serves the other land that will use the right of way, that has the right of use to a portion of the parcel, right? So remember, servient estate serves another property. Why? Because it has the land where the easement is located, and it lets the other estate, which is called the dominant estate, use that, that piece of its land, okay? So again, the dominant estate is the parcel of land that has the right to use the easement over the servient estate. Next is the grantor. Pretty easy. It's the person who gives the property interest. Now, this is not only for easements, it's also for selling property. It's the person who gives. So when you think of grantor, you're thinking of giving property. When you think of grantee, you need to think of who is receiving the property, okay? And as I said, these are a few of the key terms that were already identified for you and wanted to translate, if you will, into simpler terms so that you don't get bogged down when you are reading the rules and trying to memorize them. So what is an easement? So an easement, as I said before, is a non-possessory interest in another person's property. So non-possessory means that you can use the land, but you can't usually build on it, you can't inhabit it, and you can't otherwise occupy the land. You can only use it. So you do have a property right within that another person's property, okay? But it's non-possessory in nature, so it's limited. As I said, the land on which the easement is located is the servient estate. It's always going to belong to someone else, okay? You can't be your own servient estate. If you own both the dominant and the servient estate, then there's no need for an easement, okay? Because you can't have an easement over your own property, right? Because it's just your property. You can do whatever you want with it. The land which has the right to use the easement, again, is the dominant estate, as we discussed in the key terms. And easements can be affirmative, which is the most tested kind, which is it's usually the right to use another's land. Okay, and I'll go into a couple of examples next. And there's also negative easement, which essentially parties agree that one party is going to refrain from doing something, but that's a lot less commonly tested than affirmative easements. So what is an easement? Examples of easements would be like driveways, power lines installed on someone's property, train tracks, gravel roads, anything like that, right? Where someone can use it, but they can't really possess it, right? That's what you want to think of when you think of easements. And again, it's a legal right, it's a property right, you're legally entitled to use it, but it's usually these few. Of all the questions I've done on easements, the vast majority are these kind of examples that will come up. Driveways, power lines, train tracks, gravel roads. So there's only 4 ways to create an easement, okay? It does not matter if the MBE question is 6 paragraphs long, if it gets tested on an essay and it's asking you whatever it may be asking you. There's only 4 ways to create an easement. And you should, anytime you see an easement question, reduce yourself to that universe of only 4 ways to make an easement to really compartmentalize the rules that you likely will need to analyze to get the question right. So the first one is by express grant, by prescription, or easements can be implied, and they can be implied by necessity, or they can be implied by implication. So first, let's talk about an easement by grant. So an easement by grant is the one that is most common to think of. And it is by express agreement, which basically somebody is telling one person who owns a piece of property, the servient estate, is the one that is going to serve the dominant estate, is telling the owner of the dominant estate, hey, I'm going to grant you an easement over my property. I'm going to let you use my driveway. I'm going to let you install power lines so you can get electricity to your house, right? And these have specific requirements. The express agreement has to be in writing, so look for statute of frauds issues to come up. It has to be signed by the grantor. Again, grantor from the key terms is the person who owns the property and is given the property interest. It has to identify the parties to the contract, so the grantor and the grantee, and it has to show present intent to convey. Present intent to convey has its own sub rules. We discuss them in our lessons in our course. We won't necessarily get into it here, but always be on the lookout for that because it is a bit of an extensive rule. So the next kind is an easement by prescription. So what is an easement by prescription? Oh, sped ahead there. Easement by prescription. So an easement by prescription is an easement that is acquired, okay? So the property right to use another person's land for specific use is acquired against the wishes of the owner of the servient estate, right? The land that is going to be used for the easement. And you might say, well, that doesn't sound fair. Why would you let someone use another person's land if that person didn't want to do it? Well, again, going back to the earlier concepts of American law, part of the reason why we have these rules is because we want land utility, right? If you are there and are using the easement in a way for a certain period of time and meet all the requirements, then you're entitled to have that property interest. Why? Because we've determined that you cared about it more to gain that property interest than the other person cared about keeping you from having that property interest. So this kind of falls back on the land utility concept. So what are the requirements to obtain an easement by prescription? You have to have actual use. Okay, so if it's a driveway, you got to use a driveway. Open and notorious, which means that the actual owner, if they would have inspected the land, they would have seen that somebody was using the easement. It has to be continuous. So if it's a driveway, I would say construe that kind of broadly, right? Doesn't mean you got to use it every day, but you do have to use it continuously. And for the statutory period. So however long the statute says you have to be using it for in order to obtain it, you have to show that you used it that whole time. And it has to be hostile. Hostile does not mean that every time you're using it, you're fighting someone. It just means you're using it against the actual owner's wishes. That's enough to meet the hostile component. Quick memorizing tip. Easements by prescriptions have all the same elements as adverse possession, which is how you can take another person's property, not just an easement, against their wishes, except for the exclusivity requirement. So in adverse possession, you have to be exclusively in possession of the property. For an easement, you can share it with the actual owner. It's not required in order for you to obtain an easement by prescription. So next, it's easement by necessity. So this is part of implied easements, right? An easement that is implied by the necessity. So this arises when a property is essentially rendered without use unless it obtains that easement from the other property, which it was formally joined by. So they have to be both part of a single tract of land, okay, which were then divided. And now one of the properties is essentially useless unless it has this easement, right? So again, the requirements are, first one is they had to have been under common ownership prior to division. Okay, so you had one tract of land, it was divided into two. Now one of them is essentially without access or without use. Okay. The necessity for an easement came about because they severed the single tract and made it into two. And the dominant estate, meaning the one that needs the easement, is practically useless. And this usually will mean that it's inaccessible. Okay. It means there's no way to get in or to the property, in or out of the property without without that easement, absent being parachuted in, right? I mean, I guess you can always access land if you wanted to, but for the purposes of meeting the legal necessity requirement, is it accessible or not? So without that accessibility, the dominant estate is practically useless without the easement. Lastly, it's easement by implication. So easement by necessity, it's great because it basically says, out of this, idea of having land utility, right, that American real property law is founded in, says, well, listen, if you have a land and you can't get any access to it, well, we're going to make it so that you can have a property right to access your land through another person's land out of easement by necessity. However, a necessity is kind of hard to prove. It's a lot, right, to say, hey, I absolutely need this. So you kind of have this other standard, which is easement by implication, which is slightly easier to prove, which American jurisprudence has determined, hey, if you can prove these factors, you might not necessarily have a full out necessity, meaning you can't even get in or out of your property. But if you can meet these other requirements, you're still going to have an easement by implication. You're still going to have a property right to use another person's property to gain access to your property, right? And so what are the requirements? The servient and dominant estate have to have been under the same owner prior to division. So that's the same requirement as easement by necessity. There has to be pre-existing use prior to the division of the property, meaning the easement, right? The easement that you're trying to say that you have access to has to have been in pre-existing use prior to the property being divided into two. The use has to have been continuous and obvious, okay? And the easement is reasonably necessary for the use and enjoyment of the dominant estate, meaning the property that needs the easement, right? So notice how necessity, it's like, well, if you can't get in or out, we'll give you an easement as long as you meet the requirements. This one, it's saying, well, as long as some of the same factors are present, such as common ownership, then as long as there's a proof that there was pre-existing use prior to the property being divided and it's necessary for the use and enjoyment, and the use has been continuous and obvious, well, then we're going to say that you have an easement too. So again, keeping in mind this land utility concept. And another quick memorizing tip, easement by implication and easement by necessity, they both have the same threshold requirement, which is the servient estate and dominant estate have to have been under the same ownership prior to division. So keep that in mind. Anytime that you can group rules to memorize them, it's always a good thing because there's plenty to memorize on the bar exam. So how are easements tested on the bar exam? Oh, I got a little bit ahead of myself. So the question will generally just ask you if the easement exists or not, or it'll give you a fact pattern. Real property questions are typically a bit wordier than other subjects. They'll set it up for you and they'll tell you, well, so-and-so thinks they have an easement, so-and-so thinks that they don't. So who should the court hold for? But they're usually pretty straightforward on what they want you to determine. You want to walk through the only 4 ways that there are to make an easement, okay? Nothing else outside of that. Do not deviate from that. Use your flow chart until you memorize the flow chart. So the flow chart is the thing I accidentally skipped to, which we're going to get to now. You want to keep that flow chart in mind and use it until you learn it, because it's going to help you get through the question, no matter how dense, how prolonged it might feel like it is. it's still going to help you get through it. So here we are, right? The famous flow chart. So we do a lot of flow charts and laying questions out and rules out in this manner. Why? Because there's two main things that you need to achieve when you're studying for the bar exam, okay? In order to do well on the questions, whether they be essays or multiple choice. You have to memorize the rule, number one. And number two, you have to understand how the rule is going to be tested, how it works, so that when it comes up on a question, you know how to use the rule you just memorized in order to get the right answer, right? And that's the second part is usually the hardest, right? Because memorizing rules, if that was the only thing that you needed, then anybody with a good memory could just take the bar exam and be a lawyer, right? But it's the application of the rules that you need to understand. And that's why we developed these charts. We have different charts depending on the subject. We've already identified and worked through what helps people understand how to navigate the process. This chart is there to do that second portion that I just mentioned, which is help you understand how the rule is going to be tested. So notice here, there's only 4 ways, right? Again, 4 ways to make an easement. Easement by grant, easement by necessity, easement by implication, easement by prescription, or there's no easement created. Those are the only choices that you can have, right? Now, we start up here with, was an easement created, right? So the first question you always want to ask yourself is, take the low-hanging fruit if it's there, right? So is there an agreement by the parties? If there is, then see if the requirements of express agreement signed by grantor, identifies parties in the land, and has an intent to convey is met. Because if that checklist is met by the facts of the question, meaning you said yes to all, then you have an easement by grant, right? And so your analysis is over. You can say yes, an easement exists, no, an easement does not exist, right? Or in this case, yes, an easement exists by grant, by express grant. Now, let's say that there's not an agreement between the parties, right? Which unfortunately, that's usually how it goes. They don't want to make it too easy on you. So you go to no, okay? So we don't go to yes. We're answering questions from the fact pattern as we go along. So the answer is no. Well, was the land once a single tract? Well, if the answer is yes, then ask yourself, is the easement absolutely necessary to access the land? So notice how we took the rule here for easement by necessity, right? Which is they have to have been under common ownership, right, prior to division. And it came about because of a severing of the 2 parcels, right? And it's practically useless. So now look, that's the whole rule there, right? The rule that you have to memorize. Notice how in our chart, we're working our way through those elements by asking the questions on if they're met, right? So we ask, was it once a single tract, which shows it was under common ownership? If it by was, we're inferring that it no longer is, right? So if you answer yes to both of those, right? Then the next question is the easement absolutely necessary to access the land? If you answer yes to that question, then you're done. You have an easement by necessity, right? If you say no, okay, so it's not absolutely necessary to access the land, then you can go through this other checklist of 4 items, right? Even if it's not absolutely necessary, is the easement reasonably necessary for use and enjoyment? Does it affect the value of the land? Has the use of the easement been continuous and obvious? Is there pre-existing use prior to division? If you answer yes to all of those, then you have an easement by implication, right? If you answered no, then no easement was created, right? At least going this way, except if the property was never a single tract, right? Then we go up through here where easement by prescription, right? So you ask yourself, is the use of the easement open and notorious? Is it continuous for the statutory period? Is it hostile, right? And if you answer yes to all, then you have an easement by prescription. If you don't answer yes to all, then no easement was created. Does that make sense? And so I ask as if this is not a pre-recorded lecture, like as if you guys can answer me. But if it doesn't make sense, then rewind me and go through it again, right? But the idea is we have a chart that has all the elements of the rules that you need to memorize. But more importantly, you're navigating the rules in the context of answering facts that might come up in a question. So that being said, let's use this chart to answer an actual NCBE question. So this is a licensed question from the NCBE. Let's go through it. So this has come up in a bar exam before, which means the ones that you will see on the bar exam will be similar to these. So let's see. Let's go through it together. A man owned land along the south side of a highway. To the south of the man's land was a lot owned by a woman who lived on it in a house. Okay, so basically, this is why I went to law school, not art school. Bear with me. Okay, so here we have the highway. We know that the man, his land is to the south, right? The south of the highway. So let's just do a quick compass here, right? So we have east, west, north, south, right? Okay, so we know that he owns property to the south of the highway. So this is the man right here, right? That's his property. And we know that a woman owns a lot south of him. So the woman owns it here, okay? And she has a house, right? This is the house. Here we are. Bad as this little house that I'm drawing may seem, it's still bigger than the first apartment I ever had in New York City. That's a true story. All right, so let's see. Now we're kind of laying out what this may look like, right? So 5 years ago, the man conveyed a right-of-way easement over his land to the woman because it provided more direct route between her house and the highway. So he gives her an easement, right, for a road. So this is the easement right here, right? Okay, the easement was evidenced by a clearly marked path, as you can see there in my elaborate drawing. The document granting the easement was promptly recorded. So when they're giving you all these facts, then you can assume that there's an easement by grant, right? Because they're basically telling you, listen, we recorded it, it was given, she has it, whatever. So that's usually a good signal that that's not where the real question is going to be. It's just setting up the real question. So 3 years ago, the woman conveyed her house back to the man. The man never took actual possession of the house. So this is important, right? The woman conveyed her house to the man, right? Remember what I said earlier about you can't have easements over your own property because you just own it outright. So you can't have a non-possessory legal right to use the property because you already have a legal possessory property, right? So let's change our drawing to reflect our current situation. So we know that the woman sold her half of the property back to the man, right? Okay, so we still have that road, but it's no longer an easement, right? So, but we'll leave it there for now. So now we know that fact, and we've updated our little chart, or rather drawing there, to reflect that. The man never actually took possession of the house. When they give you a fact like that, they do it on purpose, right? It's not a red herring. So just bear that in mind. Okay, so 2 years ago, the man conveyed the house to a purchaser by warranty deed. Okay, so now he sold the house 2 months after the purchaser. So let's add that in to reflect. So now he has sold it to purchaser. Okay, 2 months after the purchaser moved in. Okay, he found out from a neighbor informed him about the easement. Okay, he then began using the path that had been marked on the man's land. When the man noticed the purchaser using the path, he erected a barricade on his land that effectively prevented the purchaser from using the path. So the man, basically, that's my barricade. The purchaser has sued the man, claiming that he has an easement over the man's land. So now, let's take all of these key facts that we have, right? With the rules that we already know. We already know that you can't own an easement over your own land, right? Why? Because an easement is a non-possessory interest in another person's land. If you own the land, you don't have an easement, right? So who are the parties here, right? The parties to sue, they talked about a woman, right? The man, but here it's the purchaser has sued the man, right? So those are our parties here. It's purchaser versus the man. So let's go back to our chart, right? So was an easement created? So is there an agreement between the purchaser and the man? No, he sold him the house, that was it. He didn't sell it to him with an easement, right? So this is not going to apply. So let's go down here. So the answer is no. Was the land once a single tract? Well, it was, right? Because the man or the woman sold it back to the man, right? And after he sold it back to the man, or she sold it back to the man, he owned both of the properties, right? So is the easement absolutely necessary to access the land? Well, let's just go back here to the kind of backstory that they give us. So 5 years ago, the man conveyed a right-of-way easement over his land to the woman because it provided a more direct route between her house and the highway, right? So the presumption is that there's probably another road somewhere that, you know, when the woman owned this, she could have gotten to the highway, but the man was trying to be nice. And so he wanted the woman to have a more direct access, but there's nothing in here saying that he can't otherwise access the land, right? This is further proved by the fact that 2 months after he bought the land, he realized, right? After he moved in. So unless he moved into it, unless he didn't leave for 2 months, right? Which is probably not true. You can assume things that are, you know, facts that are not completely irrational, that they're just what happened, right? So the man moved in, so he could probably has access to get in or out, right? He just doesn't have more direct access to the highway. So let's go back here. So is the easement absolutely necessary to access the land? No, it is not. So we're going to go this way. So now that we're going this way, we've already ruled out easement by grant. We've already ruled out easement by necessity, right? So just keeping that in mind, let's see, actual notice, purchaser warranty deed, easement public record. Well, that doesn't really help us eliminate any choices, but sometimes it will, right? So now let's ask ourselves, even if it's not absolutely necessary to access the land, is the easement reasonably necessary for the use and enjoyment of the land? Sure, it provides more direct access to the land. Does it affect the value of the land? Well, we can assume that it probably does. Sure, why not? If you can get to highway quicker, the property is probably worth a little more, right? Is the use continuous and obvious? Here's where we're going to run into a problem, right? Let's look at the facts of the question again. So 3 years ago, the woman conveyed her house to the man. The man never took actual possession of the house, right? So if he never took possession of the house down here, right, then he's not using this right of way, right? Because he doesn't need to, because he can get to the highway on his own right here, right? Furthermore, right, 2 years ago, so this was 3 years ago, right? So for a year, the man never took possession of the house. So that already brings into problem, creates a problem with continuous use. 2 years ago, the man conveyed the house to the purchaser by warranty deed. Then he being the purchaser, for 2 months, he didn't even know about the easement. He then began using the path, right? So we know that we have at least a year and 2 months of time when the easement was not being used, right? At a very minimum. So let's go back to the requirement. Is the use continuous and obvious? Well, it's definitely not continuous, right? You can say, hey, well, listen, I didn't leave the house for the weekend, so I use the easement Monday through Friday, but not on the weekend. That would still satisfy continuous, but not using it for a year and a half, right? Furthermore, the guy never took possession of the house, so he was definitely not using the easement. So is it obvious? Well, if the guy wasn't living in the house, right, the man was not living in the house when he conveyed to purchaser, then it's not obvious that there was an easement there. This is further evidenced by the fact that the guy lived there for 2 months before he found out from a neighbor, right? When a neighbor informed him about the easement. So it was clearly not obvious until he was informed of it, right? So whether or not the purchaser has an easement by implication is falling apart because the use is not continuous and obvious, right? And so if you can't say yes to all, then you're not going to have an easement by implication, right? Now, That rules out 3 of them. Let's just say for the sake of discussion, we want to see if he's got an easement by prescription, right? Well, the general requirements are open and notorious, okay? So to put the owner on notice, well, he did, the purchaser did do it open and notorious, right? Because he began using the path marked on the man's land. The man noticed, so it was notorious, it was open and notorious. Is it continuous for the statutory period? Well, we don't even know from, the question doesn't tell us what the statutory period is, right? But we do know that when the man noticed, right? So as soon as it was open and notorious, right? He erected a barricade. And generally speaking, if they're not giving you a statutory period, it's because they're not going to test easement by prescription, right? Because if they did, they would have to give you the statutory period in order for you to answer this question. So that's kind of a little bit of a shortcut to knowing that easement by prescription is not going to be tested, right? So that rules out easement by prescription. So now there's only 4 ways to make an easement. And he didn't, then the purchaser didn't have one by grant, didn't obtain one by necessity or implication, and he didn't obtain one by prescription. So that means that we went no, 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 everything leads us to no, which means that there was no easement created, right? There was no easement created. And so now let's look at an answer choice that reflects our reasoning. So the purchaser sued the man claiming that he has an easement over the land. Who will prevail? Well, we already know that there is no easement, right? No easement was created as to between the man and the purchaser, right? Who are the people suing each other here. So any answer that tells you the purchaser is going to be wrong, right? Because we know that he doesn't have an easement. So we can automatically rule out D and C and D. So now we have 2. We have A and B. The man, because the easement was extinguished. The man, because the purchaser did not have actual notice of the easement at the time of acquisition. Notice this about the wrong answer choices sometimes in MBE questions. It'll have the right answer, right? It'll hold for the right person, but it'll give you the wrong explanation. So it'll say actual notice of easement at time of acquisition. Let's just go back real quick to our chart. Is there anything in here that talks about at time of acquisition, right? No, there's nothing that says at time of acquisition. So anytime you see language in an answer explanation, in an answer choice, that is not the same as what you've been studying within those subset of rules, that's a good sign that the answer is wrong. We'll do another video later on teaching you how to work through MBE questions, but that's generally a good way to know that's a wrong answer, right? There's nothing about acquisition in any of the easement rules that we've gone over, okay? So this answer is wrong. Now, this leaves us with the man. We know that's correct because the easement was extinguished. Well, we know that he definitely gave an easement to the woman, right? It says the man conveyed a one-way easement to the woman, right? Well, we know that there was one, but we know that you can't own an easement over your own property, which means that the easement distinguished, right? And we didn't get into termination of easements here, but even if you did know terminations of easements, you would know that there was no easement at the time that the purchaser bought the land from the man, because you cannot own an easement over your own property, right? Which leaves us with A being the correct answer. So notice how we got to that, right? We used the facts, we worked it in through our flow chart, and we arrived at the correct answer, which was that no easement was created as between the man and the purchaser, right? So quick recap. Easements are non-possessory interests in another's land, which can be created in only 4 ways, as we saw here. Remember that the ultimate purpose of easement is to stimulate the utility of properties, okay? Limit government involvement, and therefore the rules for easements are written to satisfy that goal, right? So if you can show one of the 4 ways you have an easement, you have an easement. If you can't show it, then you don't have one, right? It's pretty straightforward. And use the chart to answer your questions, just like we did here. We literally used the chart to arrive at the right answer, right? And to eliminate wrong answers, which is just as important, because as you've seen, one answer will always be kind of attractive to pick, but if you stick to the rules and to your flow chart, you will know why not to pick it, okay? So reinforce good habits when you're studying. This might be a little tedious at the beginning until you memorize the chart, but it'll ensure that anytime you see an easement question, you get it right. And it's a heavily tested topic, and it's worthy of learning the correct way so that you can get all those questions correct on the bar exam.